Welcome back everybody to our study of the law of contracts. In this video we're going to be talking about the next of the major issues when we examine the creation of contractual obligations, this being the intention to create legal relations. This is the second major test that we have to think about when we think about whether or not a contract existed or not in a particular circumstance. You do this essentially after you've examined the fact that there is an agreement, which is delineated between an offer and an acceptance of that offer, and then you have to think about whether or not that agreement in question is a legal agreement, i.e. whether or not the parties had intended for this agreement to be legally binding. And then once you've done that, we will talk about the next and final major hurdle to establishing the creation of a contract, which is, of course, the idea of consideration. We're moving away, therefore, from the idea of looking at the nature of agreement within the law of contract and now examining the next major element, the idea of intention to create legal relations, a contractual intent, sometimes as it is described. So let's just take an introduction to the idea of the intention to create legal relations. So far, what we have done is examined the agreement element of a contract, the idea that we have an offer and that there is an acceptance of that offer. We've explored all of the different modes and means and methods by which this is actually established. So we've spoken about, for example, the delineation between an offer and an invitation to treat. We've talked about the ways and methods of acceptance, whether or not you can accept an offer by conduct. We've talked about the postal rule, the rule that essentially provides that as soon as an acceptance of an offer has been posted, regardless of whether or not it has actually been received by the original offeror, it is still a valid acceptance. All of these things are very, very important for the establishment of the agreement. But a simple deference to the idea of agreement does not in and of itself create a legally binding contract. Just because we have an agreement about something does not mean that we have a contract. Even if we've shook hands and we agree that one thing is going to happen, and even if we have consideration, we have something in return for something else, this does not necessarily mean that a contract is legally binding. Because in addition to all of these things, we have to think about the idea of an intention to create legal relations. Because plenty of agreements that we can come to between parties, between individuals, between family members, between anybody, can be have all of the characteristics of legally binding contracts. They may have an offer and an acceptance, they may even be consideration, but they are still nevertheless not legally binding. If I arrange, for example, to go and meet a friend tomorrow and we agree a time, that agreement exists. There is an offer. Maybe somebody offers to go and meet, to meet, and I accept that offer. But that's an agreement that isn't legally binding. Could my friend therefore sue me if I am late to this meeting, even if we've agreed a specific time? Could they sue me for breach of contract? Well, usually the answer would be no, and the reason why the answer is no is potentially on a lack of consideration, but also, and more importantly in this case, on a lack of an intention to create legal relations. When I agree to and arrange to meet a friend and we agree at a specific time, we're not doing so with the expressed intention that this is going to be a contract, at least not all of my friends at least. And then the result in that is that if this is therefore breached in any kind of way, if I'm late or if I cancel at an earlier time, this does not mean that therefore I have breached a contract. It just means that we have an agreement that has not been fulfilled. There's no legal binding nature to it. So the courts have to therefore make a delineation between agreements which have clearly got attached to them an intention to create legal relations, and then also agreements which do not have this intention to create legal relations. For the most part, we distinguish this by looking at the different types of agreements that exist. And the two major delineations that we can think of are agreements that exist within commercial contracts and the business structure that exists, in which case that there is, generally speaking, more of a presumption that there is an intention to create legal relations, or agreements that exist in social circles, like the example that I looked at previously. This can be a broad range of different issues. It could also in relation to familial circumstances in your family, but it could also be your friends meeting your friends, your colleagues, acquaintances, all of these different things. You could have plenty of agreements there, but not necessarily have them be legally binding. So Just like the example where I meet my friends, you can have plenty of different agreements that are made in what I've described here as social and domestic circumstances. So, agreement between friends, agreement between family, a parent and a child, a brother and a sister, etc., etc., etc. When it comes to these kinds of agreements, where there is a dispute and that dispute ends up in court, there is a presumption taken by the courts that these do not have attached to them an intention to create legal relations. This is the sort of baseline presumption which is established by the courts. It is then, therefore, for one party to rebut this presumption, to argue, in fact, even though the basic presumption is that domestic social agreements do not have an intention to create legal relations, this one did have an intention to create legal relations. So this is the establishment of the basic standard by which agreements that are made in social and domestic circumstances are established. Now, the alternative is that when we look at agreements that are made in commercial circumstances, the opposite is the case. It is actually the case that the courts presume that the agreement in question did have attached with it an intention to create legal relations, and it is for the opposing side to argue that it didn't. So that is there's a nice symmetry there between the two different kinds of agreements that we can generally understand in the world. We have domestic and social agreements like me meeting my friend, and you can also have business and commercial agreements on the other hand. And the symmetry that exists is that in the first instance, in the social circles instance, there is a presumption that there is not an intention to create legal relations. In the commercial instance, there is a presumption that there is an intention to create legal relations. We'll get to that in more detail in the next lesson. But let's just illustrate this point in relation to domestic and familial circumstances by looking at the case from 1919 of Balfour and Balfour. In this case, the defendant had moved to England with his wife, who was the claimant. They moved from Ceylon, which is modern-day Sri Lanka, or Ceylon, which is modern-day Sri Lanka. When it came time to move back to Sri Lanka, the wife, owing to ill health, made the decision that she was actually going to stay in England. Okay. The defendant agreed to this arrangement, and they also agreed that they were going to send around $30 a month as stipend. These payments, when these payments then stopped, the claimant then sought to enforce this agreement as a contract. Remember, though, this is a defendant and a claimant who are husband and wife. And so the result here is that the question of whether or not this arrangement had attached to it an intention to create legal relations. And so as a result of which, the failure to provide these stipend payments therefore allows for a legally enforceable breach of contract claim. The courts held that there was no contract. Because of the fact that this was a relationship between a husband and wife, there is a presumption that there was no intention to create legal relations. And it was actually for the claimant to rebut this presumption, to try and argue, in fact, that there was an intention to create legal relations, of course, which they were unable to do. There was also issues relating to consideration in this case, which we'll get to in future lessons, because of course there was no consideration in the fact that the defendant was just essentially giving a £30 or $30 a month stipend and getting nothing in return for it. So there was actually a lack of consideration too. But in terms of for our purposes and what was important for this lesson is that there was also not an intention to create legal relations. In the case of Jones and Pad Avaton from 1969, we also have the illustration of there being a presumption that exists that no intention to create legal relations existed, specifically within familial relationships. The case itself involves a mother and a daughter. The mother had made a promise to her daughter that she would provide her with a house and some money while she was studying for the bar. Anybody who is studying law should know what the bar is. Essentially, it's the process by which an individual becomes a barrister. After 6 years, the daughter had failed to pass the bar. She wasn't particularly good, and therefore the mother had sought repossession of the property. The daughter argued that she had no authority to do so, owing that a contract had been created between the mother and her daughter in the fact that there was a promise for the daughter to have a house and some money while she was studying for the bar. And again, this is illustrative of the point that there is a presumption that is taken by the courts of a lack of an intention to create legal relations, because in following from Balfour and Balfour, owing to the lack of intention, the mother did not have a contract with the daughter, and so as a result of which the mother could have done whatever she wanted in relation to the repossession of the property.